Duress in contract law relates to where a person enters an agreement as a result of threats. Where a party enters a contract because of duress, they may have the contract set aside. Originally, the common law only recognized threats of unlawful physical violence. However, in more recent times the courts have recognized economic duress as giving rise to a valid claim. The basis of duress as a vitiating factor in contract law is that there is an absence of free consent. Duress operates at common law. Pressure not amounting to duress may give rise to an action for undue influence in equity. The effect of a finding of duress is that the contract is voidable. The innocent party may rescind the contract and claim damages. The normal bars to rescission operate. The doctrine of economic duress was first canvassed by Mr. Justice Kerr in the Sibian and the Sibotra. Whilst the contract was not held to be voidable for duress, Mr. Justice Kerr did state that where there exists coercion of the will so as to vitiate consent, it should be possible to set the contract aside. However, commercial pressure was not enough. Following this line of reasoning, economic duress was found to exist in the Atlantic Baron, North Ocean Shipping v Hyundai Construction. The defendant threatened not to complete the contract unless the claimant paid an extra 10% on the contractually agreed price. Whilst the court supported a finding of duress, the claimant lost their right to rescind as they left it too long before bringing the case. In Powon v Lao Yiu Long, the Privy Council identified 4 factors to consider in assessing whether economic duress was present. 1. Did the person claiming to be coerced protest? 2. Did that person have any other available course of action? 3. Were they independently advised? 4. After entering into the contract, did they take steps to avoid it? The requirement of vitiation of consent was replaced in the Universe Sentinel with the absence of choice, where Lord Scarman stated, "The classic case of duress is not the lack of will to submit, but the victim's intentional submission arising from the realization that there is no other practical choice open to him." Accordingly, 2 elements of duress were identified: 1. Compulsion of the will, absence of choice, and 2. Illegitimacy of the pressure. Initially, it was thought that the threat must be unlawful to amount to illegitimate pressure. In Dimskal Shipping v International Transport Workers Federation, the Evia Luck, the Court of Appeal thought it necessary to determine whether the strike action was lawful to determine whether the pressure was legitimate. In CTN Cash and Carey v Gallagher, 1994, the threat to withdraw credit facility was not illegitimate pressure since it was a lawful threat. However, dicta from Lord Hoffman in the Privy Council case of RV Attorney General for England and Wales, 2003, suggests a different approach. The legitimacy of the pressure must be examined from 2 aspects. First, the nature of the pressure, and secondly, the nature of the demand which the pressure is applied to support. Generally speaking, the threat of any form of unlawful action will be regarded as illegitimate. On the other hand, that fact that the threat is lawful does not necessarily make the pressure legitimate. According to IFR Limited v Federal Trade Spa, 2001, since duress operates to deflect the will of the party rather than vitiate consent, the effect of a finding of duress is always to make the contract voidable, not void. In summary, economic duress is where a person enters a contract as a result of a threat to their financial position. According to the Universe Sentinel, there are 2 requirements: the compulsion of the will and the illegitimacy of the pressure. Where duress is established, the contract is voidable. The person threatened has the right to rescind the contract, but this right may be lost in some circumstances. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.